Good morning, everyone. My name is Helena Natt. I'm the Executive Director with the Greater New York Chamber of Commerce. And thank you for attending this very important webinar. When we e-blasted it out, I saw that it was a very popular, very timely, and very important topic that we are going to be discussing today. So first of all, I want to thank the New York City Department of Consumer and Worker Protection Commissioner, Lorelei Salas, for hosting this, this webinar. And also, I would like to thank Ben Holt for also coming on, and also Tanjilia Rahman, who I've been working with to set this up. So welcome to the panelists. I just want to give you a little bit of background about the commissioner. I did a little research, and I love introducing people because it gives me an opportunity to read a little bit of their bio. But for those who don't know her, Mayor de Blasio announced her appointment for the commissioner, and it is the largest municipal consumer protection agency in the country. So I did not know that, which is great. So you can see that we have someone here that has the knowledge and expertise. And in 2009, President Obama nominated Ms. Salas to be the wage and hour administrator at the United States Department of Labor, a division with close to 2,000 investigative staff across the nation. And she has also worked as a consultant for the Secretary of Labor, Hilda Solis, for 3 months before coming back to New York. She also worked at the New York State Attorney General's office in the litigation and labor bureaus. So I think the question, with her background and her expertise, this is a great webinar for you to ask her the specific questions, and I'll go over the agenda. Ask her the questions that you need to know to make sure that you are in compliance. So the way that it's going to work is I'm going to turn it over to the commissioner and her staff. And also there's a chat on the bottom of your screen. We are going to be monitoring the chat. Put your questions in the chat, and we will make sure that Ben and the commissioner will be monitoring it and answering the questions. And if there's any follow through, there is going to be links in the chat. I'm going to make sure I have everyone's email address. As long as we're in compliance and I have the okay, I will send the copy of the chat to everyone, so they will be able to see the links that they are putting in on behalf of the department. So right now, I know there's going to be a lot of question and answers. Like I said, put the information in the chat. We're going to be monitoring it, and I'm going to turn it over to the commissioner right now. Thank you so much.
Thank you so much, Helena, for the introduction, and to the Greater New York Chamber of Commerce for working with us and making sure that very important information is being transmitted to your members, to this audience today on this panel. I also want to introduce Ben Holt. He's the Deputy Commissioner for the Office of Labor Policy and Standards, and it is his office that actually enforces the key workplace protection laws in New York City. And so you have the right person here in the room to make sure that you get the most up-to-date information that we can give you today on the changes in the law. Tangila will also be helping us with including into the chat key links to the documents, templates, to phone numbers, contact information that you may use. And please follow up with us. If today you don't have time to ask your question, or if something comes up later, you'll be able to get in touch with us. We do want to make sure our businesses in New York City have all the tools they need to keep up with the recent changes in the law. Just a couple of quick things about the agency. We are have been around for over 50 years. We do enforce consumer and workplace protection laws in New York City, and we also have an Office of Financial Empowerment that has as its mission improving the financial health of New Yorkers. So there's a bucket of different things that we take care of. In addition to that, you may be aware that we are also a licensing agency, and we license over 60,000 businesses in New York City, businesses that range from car washes to tobacco retail dealers to electronic stores. They need licenses to operate, and they would usually come to our licensing centers or apply online for the ability to operate in this city. Um, One important thing that this type of roundtable that we're holding today is the kind of outreach that we feel is some of the most effective outreach we can do in our communities. And this is the first one we're doing this week, or actually since the paid sick leave law was amended. So it's a very important one. And please, again, thank you for participating and for bringing your questions to us. We have been since March really busy going into different communities in New York, helping businesses to understand their responsibilities under the reopening guidelines in New York State. So I want to highlight that because that is very important work that we all have to do together in order to be able to continue to reopen safely and to make sure that our numbers of infections don't increase in New York City. We want to be able to recover in a and continue that without having setbacks. So I really appreciate everything you guys are all doing to comply with those guidelines, which can be a lot, right? And so we have been on the ground and conducted business education days where we've gone door to door to many of the smallest businesses in New York City that usually have less access to some of our tools, information online, and people who are, generally not just managing their businesses, but also working in them long hours every day. So we have done this work to make sure that we can come to you if you cannot come to us, and visited over 1,500 businesses since March, and we'll continue to do that. So why are we holding this particular roundtable? The paid safe and sick leave law in New York City has been in place since 2014 and has been amended and expanded several times. But this year, the state and the federal government recognized how important, how life-saving of a benefit paid sick leave is. And as a result, in response to COVID-19, both the state and the federal governments enacted their own emergency paid sick leave laws. The state, New York State, also passed a permanent paid sick leave law. And as of September 30th, New York City amended its own paid sick leave law to conform to what the state law required, right? So that there will be no confusion. New York City employers that are covered by the New York State law would understand, will be held to the same standards under both the city and the state's statutes. So basically, the changes I'm going to describe are things that all employers in New York State are required to comply with because of state law, and our city law simply makes some changes and also conforms to those requirements. And I'll just describe a few of them, and then I hope to dedicate most of the time to just engage with you in conversation and answering your questions. And just a reminder again that Angela will be putting links into the chat that I know that Helena will later send to everyone. But these links will bring you directly to our website and specific templates and documents that you can use that we prepare for businesses to make it easier for you to have the tools you need to comply. So let me describe a few of the key changes in the law that you need to be aware of. And initially, just to say, if you didn't already know this, the paid safe and sick leave law in New York City is pretty broad in its coverage, in the sense that one can use this leave not just because because of illness, or because a doctor's visit, but people can also use it, workers can also use it if they are survivors of domestic violence or victims of sexual assault, and need to use this time in order to seek safety, in order to seek counsel or services because of their status. That is why our city law is called the paid safe and sick leave law. It is also broad in coverage because an employee doesn't need to use the leave just to take care of their own health, but they can also use the leave if they need to take care of a relative, a parent, a child, or even someone who is not related by blood, but is close enough in relationship with this individual. In addition to that, I would just want to say also that in employers also have to allow employees to use sick leave in certain situations. Like in this case, for instance, to give you an example, post COVID-19, when the state ordered most businesses to shut down, right? Only essential businesses were operating at the beginning of or in mid-March. Those employers that had to shut down suddenly and had to send people home, there is a provision in our law, in New York City law, that says in those situations under state of emergency, workers could use those days that they have accrued in order to get paid for that time when they would be out of work because employers were forced to shut down. And so what New York City law looks like now, few key changes. Prior to September 30th, domestic workers, household employees had like a couple of days of sick leave pursuant to city law, and then another 3 days of leave pursuant to state law. New York City now requires that domestic workers be treated the same as all other workers. And so they accrue leave at the same speed, and they have the same number of days as other workers in other industries. In New York City, in New York State, if you are an employer that has 5 or more employees, you are required to pay employees for this leave. And if you are an employer as of September 30th, if you had less than 5 employees, so 1 to 4, and you're, let me just make sure I get this right, but your income exceeds $1 million a year, then you must also pay for that leave to employees. If your earnings are lesser than that, then you do not have to pay them, but you have to give them the time off. And Ben, you're going to correct me probably on this.
Just one small clarification for the leave to be paid for those small employer category. It's gross profits that have to exceed $1 million. So it's not just income. So it's actually like quite a higher threshold for who would be required to provide paid leave there.
Got it. So a couple of other things. So before September 30th, there was a requirement that an employee must first show that they were employed at least 80 hours in order to qualify as an employee covered by the law for a particular employer. That requirement no longer exists. So an employee doesn't have to show that they've worked at least 80 hours for an employer in order to be covered by the law. There also used to be, before September 30th, a 120-day waiting period. That has gone away. The state law changed that, and there's no waiting period now for employees to be able to access the leave that they have accrued. Okay, so obviously this is in recognition that, like for situations like during COVID-19, for instance, You cannot wait 120 days in order to be able to use your leave. You have to be able to use it when you're sick. And so employees now, again, don't have to wait 120 days before they can access their accrued leave. I believe started mentioning this, but I don't think I completed this thought. Employers, large employers, 100, those who have 100 employees or more must give employees a minimum of 56 hours of paid safe and sick time. Now, this is effective January 1st, 2021. And so that is when the employees will be able to use that accrued time over 40 hours. Another change that employers must keep in mind is that if they require an employee to show medical documentation for their leave, and the employee incurs in costs to obtain that medical documentation, then employers are required to reimburse the employee for that cost, whether it's $10, $15, whatever it is that the medical provider charges the employee. That cannot be a cost to the employee. It has to be a cost to the employer. One new requirement also is that employees must be aware of the amount of leave they've accrued. And so employers must put that information on pay stubs or other documentation that employees get during each pay period. This is a change because in the past, before September 30th, there was no requirement to print the accrual time on pay stubs. Now that as of September 30th, that is the case. Now, we did give an extension to employers who are trying to comply, but who needed more time to do so. We gave them until the end of November to make sure that they updated their systems and that they're able to then, provide the correct information on those pay stubs. A couple of other changes is that the law now clarifies the requirement of confidentiality for complainants. So my agency really has to maintain the identity of complainants confidential. And then it makes some changes to the timing for when employers must respond to our notices of investigations. It's 14 days versus 30 days, which was the case before. Those are some of the most salient changes, I would say. And if Ben, do you think like there's anything else we should mention right now?
Just on the pay statement requirement, because I know we've gotten a lot of questions about this. What the changes to the law say are that you have to provide the information about someone's sick leave accruals and balances each pay period, but it doesn't strictly have to be on the pay statement. It can be done on a separate document if that's easier. I think this is also an area where we anticipate that we're going to be issuing some additional guidance, if not rulemaking, over the coming months. But for example, an employer who has an electronic system where an employee can freely access their balances, we think would suffice for this purpose. So it doesn't strictly have to be on the pay stub. There is some more flexibility there for employers to adapt it to the systems that they're using, provided that employees do have free and open access to the information.
And so I would just, again, remind folks that we have put together some model forms for businesses to use, which they can simply download from our website. And I know that, again, Tangela is busy adding links to our frequently asked questions, to our models. We have a model form that employers can use in order to give an employee who wants to request, for instance, employees may request to make up missed work instead of using their earned safe and sick leave, as long as this is consensual, that is allowable. and their model forms, like I said, on our website. I'm not sure what translating those are now. Typically, we translate a lot of our materials into several different languages. We also have the notice of employee rights. That is a new requirement, right, Ben? This is a notice that must be provided, I think, for certain employers.
Yeah, and the notice is an existing requirement, at least in some respects. It's been around since paid sick leave went into effect in 2014. What's new is we've updated the notice to incorporate the amendment, so it has, you know, the latest information. The other piece that's new about the notice is that previously it was required only to be distributed to employees when they start working. That continues to be the case. It now also needs to be posted in the workplace in an area that's accessible and visible to employees.
That notice of employee rights, we have already translated it into Spanish. So we have it in English and Spanish, and we're working to translate them into up to 26 languages. So again, those are things you can print as an employer and just distribute as is. It already has all the information it needs to have. And then there's also for the smaller employers who may be struggling to figure out the accrual system. We've had for a number of years already, and we continue to have some tools in Excel where you can use these templates to keep track of the hours worked and the accruals on a daily, weekly, or bi-weekly basis, and there are instructions with each one of these tools. And again, those can be accessed online on our website. So I think that I'm going to stop there so we can now dedicate the rest of the time to questions, Helena, that you may have already received, or other questions that may be coming up in the chat.
Thank you, Commissioner, and also thank you, Deputy Commissioner Ben. So let me go through this. She has the links. Someone, while I'm asking this question, please put for all the attendees, and we have 47, which is really great. Put your questions in the chat. One person asked, I am an architect and owner of my own PLLC. I am the only full-time person working in this company. I need to hire a part-time employee to help take on the workload. Do I need to pay a part-time work sick leave? And they put the email address. So the question is, do they need to pay a part-time worker sick leave?
So yes, part-time workers, temporary workers, they are all covered by the law, except that, and I didn't say this earlier, but the accrual rates, it's you accrue 1 hour of sick leave for every 30 hours worked, right? So if you are a part-time working worker only employed 1 day a week, 2 days a week, you are going to be accruing at a slower pace than someone who is working full-time for an employer, right? So yes, the obligation is there, but obviously it's proportional to the number of hours that they're working.
Thank you. Another question regarding the 56-hour increase over the 40 hours. I am unsure which my company falls under. I am with a staffing firm and our number of employees fluctuates. Currently, it's under 100 employees, but that may change at any point during the year. Because of this, do I automatically pay out the 56 hours of leave?
That's a really great question. And I believe, Ben, that we use some sort of average when the number fluctuates, right? Can you explain that, please?
Yes, that's right. So for an employer, if your business size varies, what you would do is you would look at your current calendar year and take the average number of employees per week to figure out if you are at that 100 employee threshold or not. If you've been operating for a longer amount of time, it could get a little bit more complicated, but generally you would look at your average number of employees over that calendar year period. So if you are overall averaging 100 or more, then you would meet that 56 hour threshold. And we have some additional information in our FAQs that the commissioner mentioned about this, going through some examples and scenarios of how you would do that.
Thank you. Another question. I love that people are participating and you're able to answer the questions. Are these rules or laws for the whole state or just within New York City? We have a business in New York City and upstate New York. Good question.
The majority of these requirements are throughout New York State, right? And that's why we had to go to our legislators in the city in September to make sure that we updated our city requirements. But Ben, do you want to talk about the sort of like the things that are specifically applicable only to New York City, if there are any?
There are several. And you know what the standard is now with the state having passed a permanent paid sick leave law is New York City can also enforce and have a paid sick leave law provided it meets the floor that is set by the state. So you know, one thing actually, and if we haven't already, we'll put this link in the chat, because this is now an area that's regulated, at least within New York City, both by the city and the state. The state has also created a paid sick leave page, and we'll share that link. And that's another source of information you should be checking. But there are certain differences. I think by and large, the amendments, you know, align the city with the state law so that in most of the big respects, they're the same. But New York City does in certain places exceed what the state offers, and certainly could do so in other circumstances in the future.
Okay, thank you.
I don't think you said. Can you give a couple of things that are different or not?
You know, there aren't a huge number of differences right now.
Okay.
The scheme is largely is fairly similar. You know, the pay statement requirement is a New York City requirement that does not apply statewide. Coverage for domestic workers. I'm not actually positive exactly what the state law says about that, but that may be another difference where in New York City you have to provide the full 5 days of paid sick leave to a domestic worker.
Okay, great.
We have we have a lot of questions. So this is as a staffing firm that employer, I must say, temporary employees at different job sites. Do we have to have this policy posted at all the job sites? We have it posted in our physical office, which employs temporary employees. So I guess they want to know what for the job site, you know, if they have different job sites, do they need to put it in?
It's a good question, and you know, at the end of the day, part of the answer depends on who is employing those workers. You know, if the job site separately is employing them, then they would have an independent obligation to post it at each job site where they were employing someone. And separately, you know, if there's a job site where there's another employer, they will also have an obligation to have it posted with respect to their own employees. So I think in most instances, it is going to need to be posted, but it may come down to whether or not, you know, who actually qualifies as an employer in any given situation. But certainly a staffing company would have to have it posted in their own offices at a minimum, and it may also be required to be posted in some of the other locations.
And also better safe than sorry type of thing, just post it.
Yeah, and I will say one of the changes on the updated notice we've done is we've streamlined the information that's in it. It's I think a simpler one-page document now, so which makes it easier to post, obviously.
Well, that's very important. How would it work with CBA employees who have 40 hours of sick time? 40 hours of sick time a year, 2 weeks vacation a year.
These are collective bargaining agreements, so employers that have unions in them. Do you want to take this question?
Sure. So the New York City law and the New York state law also tracks this. So it's the same standard for the city and state here. There is a carve out in certain circumstances for employees covered by a collective bargaining agreement. The general rule is that as long as the collective bargaining agreement, one, expressly waives the New York City law, and going forward also it would need to expressly waive the state paid sick leave law. So you have to, the CBA has to, very specifically say that it is waiving the city's law. And then the second requirement is it also has to provide a comparable benefit to workers. Typically, that would, include things like what you just described, at least 40 hours of paid sick leave. But I think also certain other incidents to make sure that it would qualify as a comparable benefit. For example, if workers were given 40 hours of sick leave, but the CBA allowed them to be disciplined for using that leave in contravention of city law, we don't think that would qualify as a comparable benefit.
Then can you, what happens if, sorry to add this question, but this is another take on the CBA issue for employers who just have a blanket 20 days, let's say, of PTO, right? 20 days of PTO, workers can use it for anything, sick leave, vacation time. Would that satisfy the requirements as long as there's a sufficient number of days where people can use it under the same guidelines that New York City requires for sick leave? Because some employers just have a pool of hours, right?
Yes, it would. So there's no kind of magic language that it has to be called sick leave or only be available for use for sick leave. It could be a more general PTO policy, but as long as there are at least 40 hours of that general PTO or other leave that can be used for sick leave purposes, so effectively on the same terms and conditions as required by city law, then it can count towards the city requirement. And just kind of one last quick point on the CBA question. I said the general rule was meeting both these elements of a waiver and then also the comparable benefit. There are two industries that are treated differently, which are construction and the grocery industry. And for those two industries, the CBA only has to have the express waiver for city law not to apply. So we don't do that second step of a comparable benefits analysis if it's construction and grocery.
Okay, good. We have like 15 questions in the queue. As I understand the law, unused sick time can be rolled over to the following year. Is the requirement that this is an indefinite rollover such that an employee who rolls over sick leave can be 2 years in a row, can end up with 120 hours of paid sick time in year 3?
So in theory, yes, that could happen, but there's a few caveats to attach to that. One is that only the same threshold amount is protected for use in any given year. So let's say an employee rolls over time from 1 year to the next, accrues additional time, and has 60, 70, 80 hours in their bank. In any given calendar year, it's only 40 hours that are covered by our law and have to be made available on the terms required by city law. Now, generally, employers have to allow a worker to carry over their sick leave from year to year. However, they do not have to if they use a front-loading system instead of an accrual system. What that means is the commissioner earlier mentioned that workers accrue 1 hour of sick leave for every 30-hour worked. Employers have the option of just front loading, giving someone the 40 hours at the beginning of the year. Many employers that we see do that, I think, just for administrative and operational reasons. I think it's easier to just sometimes give the leave rather than do some of the record keeping throughout the year. If you front load the leave to your employees, then you don't have to carry over the prior year's sick leave.
Mm-hmm. So even though they can continue to accrue, the law only requires employers to pay up to, right, 40 hours of sick leave each year, or 56 hours going forward for the bigger employers.
Yep.
Okay. Someone asked, I'm a business owner who has 10 employees. We have a general PTO package that folks can use for sick or vacation time. Do I need to be specific about what is sick and what is vacation time now? We offer a generous PTO that can be accrued that exceeds the minimum number of hours of sick and safe leave.
So there's no need to distinguish between the two. However, at least 40 hours or 56, for larger employers. But in this case, at least 40 of those hours have to be available for use on the terms and conditions of city law. So that means not just that it's available as sick leave, but it can be used to care for a family member. Or it could be used for safe leave purposes to deal with the fallout from a domestic violence or trafficking issue. So it's not, I hesitate only because I don't want to say it's not quite enough just to say that it's sick leave. It has to be available for sick leave consistent with the requirements of city law. And provided that's the case, then yes, it's fine for it to be a generalized policy. And you don't need to provide more leave if someone uses up their 40 hours for vacation. They don't have to then get an additional 40 hours for sick leave, as long as that time was available for them for use as sick leave, whether they used it as vacation or something else, doesn't matter.
I think I would just give an example about this because I think it comes up in situations where an employee, for instance, says, I tried to use my sick leave, but my employer said, I need to give them 2 weeks notice because that's what our PTO says for vacation time, right? But if you're sick, obviously you need to use the leave. You only need to give your employer like reasonable notice that you are sick. And reasonable notice could be a day, it could be one night because a few hours because you just got sick that morning, right? And so if the employer comes back and says, yes, they can use the leave, but they need to give me 2 weeks notice every time, then that would not be consistent with our sick leave requirement because our sick leave needs to be able to be used when employee is actually sick, right? So that's one, like, I think for people to remind, kind of keep in mind, right? That that's what we mean by being consistent with the sick leave requirements.
And to follow up on that, someone just asked, do they have to take the manager's approval on a sick leave form to avail for sick time hours?
I'm not totally sure I understand the question.
It says, what is the change in the application process of sick time for an employee? Do they have to take the manager's approval on a sick leave form to avail for sick time hours? Regarding the form, I don't.
Do they have to fill out a form?
There's no requirement under city law for any particular process, and certainly there's no obligation under city law to get manager approval. Employers can set up their own processes and procedures for how someone is required to ask for sick leave, but that's not prescribed by the city law. Really, the main limitation is those procedures can't be too onerous that they effectively block someone from using sick leave.
Here's a good question. We are a company registered in Pennsylvania. However, we have significant number of employees in New York City working at one of our customer site. Technically, these employees are guided by the Pennsylvania law, but since they are located in New York City, will this law become applicable?
Yes, this law applies to any work performed in New York City. And I'm not giving anyone legal advice, but I don't think the premise is quite accurate that Pennsylvania law applies. I think there's a variety of New York State labor and employment laws that would apply to someone working in New York City, regardless of where the employer's operations are based.
Okay. Someone asked, if an employee is on a layoff for 7 months and they return to work, will their sick time be prorated, or will they still require to provide all 56 hours, even if they did not work the entire year?
So sick leave balances apply on a year-to-year basis. Employers can determine what their calendar year is for sick leave purposes. It could be, January 1st through December 31st, or it could be something else. And that's the time period that you look at. Someone who has accrued time within a calendar year is entitled to use that time. So if someone had accrued time early on, is furloughed for 7 months and comes back within the same calendar year, then that leave should still be available to them when they come back.
Someone asked, do these hours have to be separate from personal time off, or can they be combined? For example, we offer 40 PTO, which can be used for sick or personal. Do they need to be broken out separately?
No, they can absolutely be combined.
Okay, good. Does an employee have to be sick, or can it be taken for any reason? Do employees have to request in advance? I know you've answered some of these. We have employees that request the same day for pay, and other times a few days after they have taken the day, requested it to be paid.
I mean, I'll start and then you can complement that. So I described some of the reasons why employees can take sick days, right? So it can be for an illness, it can be preventative. So I have a doctor's appointment that I need to take annual checkup. That would also be a valid reason to take to get paid for my day, right? My time. And in some cases you'll be able to give more notice, right? So if it's a medical appointment I'm setting, I can give my employer more notice and say, in 2 weeks I'm having this appointment, I'm going to take part of the day off. But if I just get sick today and I end up in a hospital, I may be in a situation where I cannot come back to my employer and say, oh, I need my sick time. I will only do that once I probably get back to work after I recover. And so in that situation, I will be asking to get paid for those sick days later on, right? At a later date when I'm back at work. So in terms of that, I think the timing of when I'm entitled to get paid for that, I mean, when I make that request, I mean, the employer should be providing it anyway, right? But I could be asking right before, on the same day I got sick, ahead of time, or I could come back later and say, this was a valid reason I was out sick, right? So that answers the question, I think. But Ben, is there anything else to add there?
No, I think that was a great explanation. I mean, the idea is basically it has to be reasonable notice under the circumstances. So if you knew that you were going to be out, employers can require notice, and I think it's capped at 7 days advance notice under the law. So you can require up to that, but that's only if someone knows they're going to be out. And if they don't know, they only have to put the request in once it's practical for them to do so.
But the other part of the question, I think, was about for any reason, right? And I think that's important to, again, say in New York City, the law, the language is pretty broad. You can use that leave also as a survivor of domestic violence, right? For instance, so if I need to go to court to get an order of protection, I can use that time. If I need to set up a time in a new school district because I had to leave my home and I have to register my son in a new school district, that is potentially also a very valid justification for using that leave. If I need to take my child or my grandparent to the doctor, I can also use that time. It's pretty broad in coverage, but it covers safe leave and it covers sick leave situations. And I mentioned a couple of other things, which was the situation in which an employer is forced to close as part of the shutdown early during the pandemic, right? An employer had to close by order of the government. In those situations too, if an employee has already accrued their leave, they could use some of that time after getting sent home or being laid off and say, well, I had 3 days of sick leave that I had accrued already, and therefore I want to get paid for those 3 days because you shut down the business and it was, a government mandated shutdown. And that is one of the provisions under New York City law for which you are allowed to claim that pay.
Yeah, and there's one quick addendum to that. Another use that I think is very relevant to the crisis we're going through now You can also use accrued sick leave to care for your child if your child's school is closed due to a public emergency. So someone, again, this is not a new amount of leave that has to be given for this purpose, but if someone has accrued leave and their child's school is closed, they would be eligible to use sick leave to care for a child in that situation.
Oh, that's really important now during COVID. If an employee leaves the company with a carryover from previous years, is the company required to pay the balance upon employee leaving? And what if the employee is fired for misconduct? Is it forfeited?
Ben, maybe you can answer this, but I believe that employers are not required to pay out the sick leave under New York City law. You're just required to make the leave available. But if an employee does not use it, employers do not have to pay it out to the worker who leaves, right, or who's fired. Now, some employers have different policies in place, right, where they say, and they even give you a manual with your benefits, and you know, if you promised other things, you might still be obligated to comply with that promise, to meet that promise, but that's not New York City law, right? And then I forgot the second part of the question, but maybe you remember, Ben, something about, well, it's the same answer, right? If someone is fired for cause, it's not that they forfeited because of that reason, the sick leave, but again, under New York City law, there's no requirement to pay it out. It's only required to make it available when someone is employed.
Someone asked, sometimes employees request sick time off for leisure time, like a vacation. Is an employer entitled to pay in such instances?
So employers are required to provide the leave for the reasons that the law states, right?
Right.
If an employee wants to take vacation, obviously, if vacation time is available to them, they can use that. And some employers, that, as you said, they put it all into a pool, they can use the time regardless, right? If an employee files a complaint with us and says, my leave was denied, and we ask questions and they say, well, I wanted to go on vacation, we would tell them, well, this is not a case that we can pursue because you were not requesting the leave for the reasons the law says, right? But the one thing that I would say though is that employers cannot ask for documentation on the reasons for the medical leave or the safe leave unless the worker is taking more than 3 consecutive days together, right? So if I take more than 3 consecutive days, my employer can now say to me, well, now I really want you to show me your medical documentation or your safe leave documentation. And like I said earlier, if I have to pay for that, you have to reimburse me, but you can ask for it, right? Yeah, so that's the answer.
Can PSL be used to extend a paternity or / maternity leave?
I think given the breadth of the uses that are protected that the commissioner was explaining earlier, it possibly could, but I think it would be somewhat case specific. You know, purely to do childcare following a period of parental leave would probably not be covered. But there are certainly many, you know, I can envision many different scenarios in which there could be some underlying reason that would be protected. But as a general matter, probably not.
I think you answered this. Is it okay that sick and safe time, 40 hours is accrued? Do we have to front load this time?
You do not have to front load it. Yeah. It's an option that employers can choose to, but no one has to front load it.
Are there any leaves that people with children that are doing virtual learning, I was waiting for this, or ways to protect my position? Or would it just be FMLA I would have to take?
given that unfortunately remote learning is not a temporary circumstance, even if the 5 days under city law were available for that, it would obviously be very limited. I think FMLA or potentially paid family leave under New York state law is probably the better vehicle for someone in that situation.
So it would be a different state law, not the paid sick leave law under New York State or the New York City paid sick leave law, but the paid family leave law could be an option.
This is a question to the deputy commissioner and to the commissioner on behalf of the Greater New York Chamber of Commerce. Are enforcement considerations being made to ensure businesses aren't overly burdened during these difficult economic times?
So one of the things that I mentioned earlier is that we had to act very quickly in New York City to update our law to conform to New York State law, right? And in recognition of that, obviously, we decided to grant employers additional weeks. Those who were trying to actually, in good faith, make an effort to comply with the law and they needed more time, we said you can have until November 30th to update your pay stubs or whatever documentation you need to provide to workers. We've come up with a number of tools to make sure that everything that we can do to put in your hands so you don't have to do it yourselves, we'll do that. If you have ideas for anything else, we're happy to do that. During the pandemic, we took the approach that we wanted, especially in situations of paid sick leave investigations, what we wanted was to focus on immediate compliance. As you know, so important to make sure that this law is in effect, that people know it, and it's important for employers themselves, for their own safety, for their own health, that the workers don't show up to work while sick, right? And so we really put a lot of priority on making sure that we wanted the employer to immediately come into compliance if they weren't already, and to then focus on individual redress for workers who were affected or denied the leave. So, we certainly took into consideration that it was a financial crisis. And again, the number one priority was to move forward with complying with the law. It's definitely something that we've been concerned with, and even in terms of like the issues that have come up to our office from the worker side, it really has been mostly about paid sick leave and compliance with the guidelines, right? I think everyone, and I've seen a huge interest from the business community in making sure that the reopening happens in a safe manner. So the focus has been on that, reopening safely in compliance with paid sick and sick leave law. We haven't had a ton of other types of complaints, to be honest, because I think everyone is focusing on their health and hopefully defeating the virus. So yes, we've done all the outreach I described earlier as going door to door to make sure that employers again understood all of the guidelines that New York State put together, and then the city tried to distribute through all the channels. And that is, I think, a way in which we can make sure that not only are we enforcing the law, but we're also making sure that you have the information to comply. And we welcome more ideas on how else to spread the message.
Okay. I think that is any other questions? And then you also, we had a bunch of questions here from the chamber. I think you answered on why was the paid safe and sick leave law amended? You went through that at the beginning. What are the new obligations for employers under the law? We covered that. What resources are available to employers to comply with paid safe and sick leave law? You guys covered that really well. And what suggestions do you have for employers to ensure that they're in compliance? I think you guys really covered what the employers need. Is there anything else that you want to touch on before just to close it out.
I think just thank you again for providing us with this opportunity to speak directly to small businesses and business owners in general. The information on our contact, our email address is on the chat. Please do reach out to us if you have questions following this roundtable. And again, I just a call to work together on this. This isn't really about businesses versus workers versus consumers. It's not about picking a fight among the different stakeholders. That's really the reopening, right? It's for all of us, for our entire city. Complying with paid sick leave law just helps to secure our public health, right? This is the reason why laws of this type were passed, to make sure that we prevent the spread of disease. And again, finally, the state and federal governments recognize that need. Because of that too, there's been a lot of confusion about for businesses, what is it that I should be looking at, the city law, the state law, the federal law. If you reach out to us, we have dedicated lawyers and attorneys, investigators who will be able to answer your questions. So do come to us if you have any other questions, or if you want to know where exactly our materials are. We welcome that. Thank you.
Thank you. Well, you know what, to Commissioner Lorelei and Deputy Commissioner Ben Holtz and Tindjila, thank you so much. We really, really appreciate your time. And to put to communicate the information is so important, because especially during COVID times, and also even before COVID times, small businesses, especially small businesses, don't have the resources for this information. Mm-hmm. So, and to go to, no offense to the larger law firms, but if you're on a tight budget as a small business, like I said, the resources are not there for them. So we really appreciate this information. I thought it was very timely. There's a lot of information that the businesses will have, so they make sure that they're in compliance. And it's a safety precaution for the employer and the employee. So it works well together. I will send everyone, if you have it, everyone's who is attending this is gonna get a copy of the chat, because it does have a lot of informative links on there. So again, thank you again so much. I'm going to send you guys a copy of the chat also, and we can talk off of the meeting. I know that you guys are have a schedule to keep. So thank you again, everyone. And like I said, thank you for joining us. This is the Greater New York Chamber of Commerce. We, for those who don't know, we have a database of over 30,000 different business and civic leaders that we communicate with on a daily basis. We have a lot of informative webinars that we'd like to make sure that the businesses know what is going on, and to make sure that they have the resources available for them. And then also mark your calendars, December 8th, we are doing a virtual business expo, and probably following up with our monthly celebration of Small Business Fridays for complimentary informative webinars. Again, thank you so much, everyone. And be safe. I always say, wear a mask. We really want to keep businesses open. It's not a political statement. We want to make sure that the businesses stay open. And it's just really important for the economy and to make sure the businesses grow. So thank you again.
Absolutely. Thank you. Take care, Helena.
Thank you.
Bye-bye.
Bye.